Good evening to you all. My name is Christoph Paulus and I would like to welcome you to the Asser Institute and to this new Supranational Criminal Law or SCL lecture. Now, the SCL lecture series is a series on international criminal law and has been organized since 2003 by the Asser Institute in cooperation with the Coalition for the ICC and the Grotius Centre for International Legal Studies of Leiden University. On the 22nd of November 2017, the International Criminal Tribunal for the Former Yugoslavia, or ICTY, rendered judgment in its final trial in the case of prosecutor versus Ratko Mladic. After more than 5 years of trial, the rendering of the judgment marked the end, not only of the proceedings in this case, but also of the work of the ICTY. As one of the biggest war crimes trials in history, it presents numerous challenges and lessons that are relevant for other present and future international courts and tribunals. And because of this, I'm very happy that we have an excellent speaker for you tonight, who is in the unique position to give an insider's view of these challenges and lessons. Jonas Nilsson, he has worked at the ICTY between 2005 and 2017 as a senior legal officer and legal officer. And during the last years, he was the team leader in Trial Chamber 1, assigned to the Mladic case. He has a Master of Laws from the University of Lund and a Master of International Human Rights Law from the Royal Wallenberg Institute, which is also based in Lund. Jonas Nilsson has previously worked on human rights and refugee law at Amnesty International and at the Swedish Helsinki Committee. Between 2001 and 2003, he lived in Kosovo and he worked at the Ombudsperson Institution in Kosovo as the Director of Investigations. And he has published many articles on international criminal law and human rights, including articles for the Oxford Companion to International Criminal Justice, the Code of International Criminal Law and Procedure, annotated, and a commentary on the law of the International Criminal Court. So, Mr. Nielsen, thank you very much for being with us tonight, and you have the floor.
So, thank you very much. So, thank you, Christoph. Thank you also to the Asser Institute for organizing this event. It's a pleasure to be here. And it's an honor to be part of these lecture series. I brought with me the Mladic judgment. You see there in front this pile of volumes. I wasn't going to read out loud from it unless you specifically ask for some portions to be read out. I just wanted to bring it to show you what it looks like in printed form. You might have seen it in electronic form. We decided some weeks ago to call this presentation an insider's view, and I talked to a friend the other day, and said there's a little bit of pressure. I have to think of some inside information to give you. I have to think about something that no one else can know. That's some kind of information I should give you. My friend told me, you can just tell them what is in the judgment, because there cannot be more insight than that. There's no one who has read it and no one who will ever read it. We're not friends anymore, but he did have a point. It's striking to me when I look at my career at the ICTY, how both the length and somehow the complexity of the trials have developed, they have become more and more complex, and certainly the judgment have become longer and longer. The first case I worked on was the Krajisnik case, the first case we wrote a judgment in. When we started to put together that and finalize that judgment, that was in 2006, we realized that it was coming close to 500 pages. We were then told by registry at the time that this could be a problem, because if you issue a volume that is more than 500 pages, it will simply not hold together, it will fall apart. So there was some kind of limit of 500 pages. So we did manage to have it under 500, I think 450 pages or so. But since then, of course, other chambers and our chamber as well started realizing that you can in fact have more than 500 pages in one volume, and you can issue how many volumes you would like. So this is somehow where we have ended up now. It's 2,500 pages. It's 5 volumes. 4 of them are public. The 5th one confidential. I do accept that not all of you have managed to read it before this session yet, but I'm sure you will at some point. I was going to, therefore, provide you with a summary of the case, so at least if nothing else, we'll walk out of here with some kind of minimum understanding of what the case was about. So I will start with that. See if I can get. There we are. So Ratko Mladic, born 1942, he was a military man. He did his military career in the Yugoslav army. During the 1960s, 70s, and 80s, he rose in the rank of the Yugoslav army, and at the beginning of the conflict in 1991, he was a major general, and he was serving in Croatia within the Yugoslav army. When the Bosnian Serb Republic was proclaimed in 1992, he was appointed commander of the Bosnian Serb army that had just been established. He was then the highest military leader in the Bosnian Serb Republic. He answered directly to the Republic's president, Radovan Karadzic, and he remained in this position throughout the conflict in Bosnia, so until, well, I think even till the end of 1996. The indictment against Mladic was filed on 24 July and 14 November 1995, so during the conflict in the former Yugoslavia. He was not arrested until much later than that, not until May 2011, some 16 years later. The trial started within a year after the arrest and lasted for a number of years until, as we said earlier, in November last year when the trial judgment was rendered. And the case is currently on appeal, or will be on appeal. I haven't followed the absolute latest developments there. Besides these time indication, I wanted to give you maybe a few more numbers just to get a sense of the scope and the size of this case. During the trial, the trial chamber heard or received evidence from 592 witnesses. Of those, 377 appeared before the chamber, so either through as viva voce witnesses or we call Rule 92 ter witnesses. Of those who came to testify, there was a slightly higher portion that were called by the defense. In addition to that, you had 211 witnesses who were called, whether there was a written statement or was admitted into evidence pursuant to Rule 92 bis, 92 carter. You're all sitting and trying to do the math, I see, to see if this all adds up. And I'll give you another few seconds to realize that it doesn't quite add up. 377 plus 211 is probably not 592. These are numbers that comes from the judgment, so either there's something wrong in the judgment, or maybe there is an explanation for this. But this is an encouragement for you to read it, and then you will find the answer to this puzzle, hopefully. In addition to witnesses, the trial chamber also admitted into evidence some 10,000 exhibits. There is no real way I can explain to you or somehow illustrate how much that is when you have to read and analyze and process these documents for a judgment. Some documents, of course, were 1 page or 2 pages. Others a bit more, and there were even some documents that were in the hundreds of pages. So it's a huge amount of material that were processed or admitted into evidence and processed for this during this trial and for this judgment. The case against Mladic covered events throughout the conflict in Bosnia and Herzegovina from 1992 up to the end of 1995. Following the secession of Slovenia and Croatia from Yugoslavia, the eyes were on Bosnia-Herzegovina and see what road they would take. Bosnia was mixed ethnically. There were Bosniaks, Serbs, and Croats in particular. The positions that the Bosnian Serbs took, at least initially, was that Bosnia should remain within the former Yugoslavia, or within Yugoslavia, which at that point was a rest Yugoslavia, which primarily meant Serbia and Montenegro. In particular, the Bosniak side were pushing for independence. There were political negotiations in 1991 and up to the beginning of 1992, also with international involvement, in order to somehow resolve or try to find a solution. There was no solution to find, at least not one that could satisfy all parties. So Bosnia-Herzegovina in 1991 was marching towards a conflict. In March 1992, I believe it was, Bosnia declared independence. Around the same time, the Bosnian Serb Republic proclaimed the Bosnian Serbs, I should say, proclaimed their own state, their own republic. Despite these negotiations that had been held in 91 and 92, the Bosnian Serb side, and I'm sure the other sides as well, were at the same time preparing for somehow the plan B or eventualities, which was a conflict or claiming their own state. The Bosnian Serb side had one significant advantage in this respect. They were inheriting the army and the soldiers and the military, the might of the old Yugoslav army. So in all facilities, equipment, and also soldiers were stationed in Bosnia, basically became part of the Bosnian Serb army. The conflict in Bosnia broke out for real in the spring 1992, April or May. And over the years that followed, the conflict took different twists and turns and had different forms. But in the early stage of the conflict, it seemed to follow a certain pattern, at least in the municipalities where the Bosnian Serbs, there were claims as Bosnian Serb Republic territory. And that pattern was that the Bosnian Serb army, together with police force, together with paramilitaries, other volunteer units, attacked areas inhabited by Muslims, villages, municipalities. In some cases, many of these inhabitants were killed in these attacks. Majority, however, were detained and imprisoned, and many were deported and forced out of their homes and forced out of the municipality altogether. Those who were arrested and detained, they stayed in detention in camps, various camps, throughout the summer of 1992. And those who ultimately survived this experience were finally also very often deported, sent out of the Bosnian Serb Republic territory. The treatment of the civilian population during this phase of the conflict, so in the early stages in the summer of 1992, is what we often are referred to at that time and still as ethnic cleansing. It's in particular the detention, forcible transfer of the civilian population that has got this description. So these events in 14 municipalities in Bosnia and Herzegovina is what is become more what somehow classified by the prosecution as the first part of the case against Mladic, so the ethnic cleansing in the municipalities. The second part of the case concerns Sarajevo. Early in the conflict, the Bosnian Serb army had taken positions around Sarajevo, placed artillery and snipers, and there was a prosecution's case that throughout the conflict, in fact, these Bosnian Serb soldiers were terrorizing the civilian population in Sarajevo through shelling and through sniping. So this went on for a number of years, and that's the second part of the case. Moving to the third part of the case, in May 1995, NATO was carrying out campaigns, or bombings, I should say, against the Bosnian Serb army, because they wanted to, well, as a pressure to try to get the Bosnian Serb side to agree to certain demands by the international community. At this time, the Bosnian Serb army launched a campaign of arresting and detaining unarmed UN observers. They brought these observers to potential military targets, like bridges and various buildings, and kept them there, chained them to or in other words, kept them in those places, making sure that NATO knew that they were there, so in that way shielding these buildings from attacks, but also threatened to kill these UN staff members unless the NATO bombings would cease. So that's the third part of the case. Finally, the year of 1995, which was the last year of the Bosnian conflict, saw perhaps the most extreme form of violence during this conflict, and a crime that somehow come to define the whole conflict. In July 1995, the Bosnian Serb army approached the village of Srebrenica in eastern Bosnia. Fearing this approaching army, the women, children, and elderly left their homes in Srebrenica, in surrounding villages, and left for another place north of Srebrenica called Potocari, another village. There was a UN base at that time, held by a Dutch UN battalion, and they sought shelter there. The men from these villages, in Srebrenica and others, were also fearing the approaching Bosnian Serb army, but perhaps with less trust in the protection of the international community, decided to try to make it on their own and to gather and try to reach safe territory, that is Bosniak territory, by foot. So they gathered in a long column and set off for Tuzla. In Potocari, after a day or two, the Bosnian Serb army, including Mladic himself, arrived. It was then decided that the women, children, and elderly should be removed and forced to go to Bosniak territory. Moved to Bosniak territory. So the Bosnian Serb army organized buses, and at gunpoint made sure that the civilians were entering or boarding the buses. Buses took off, and then at a certain point they stopped and they were let off and asked to walk to safe territory. So that was the fate of the women, children, and elderly who were in Potocari. In the meantime, the men in this column were trying to make it to Tuzla. The Bosnian Serb army started to intercept the column by shooting and shelling at it. Many of the men and boys were killed in these attacks, in these interceptions. The column consisted, as I said, of men, mostly or almost exclusively of men in some military age. There were soldiers and civilians. There were some who were armed, but mostly were unarmed. Most of the men, there were some that were killed in the column, but most of them, in fact, were captured and taken and kept and held at various fields, in schools, and other places around in the region. There might have been some initial confusion about what to do with so many prisoners, so many detainees. We're talking about many thousands. But very soon a decision was taken that the men should be killed. They were then brought from the places where they were held to fields and other places and killed there and often buried in the same place.
So who made that decision?
Let's wait for it.
Yeah. Okay.
So in this process, it's estimated that about 7,000 or 8,000 men were killed in a matter of just a few days. So, in summary, the 4 parts of the case are the crimes committed in 14 municipalities in 1992, what we described as, or mentioned as ethnic cleansing, the shelling and sniping of Sarajevo, which happened throughout the conflict, 92 to 95, the hostage-taking of UN personnel, which was primarily in May 1995, and then the killings in Srebrenica, July 1995. The trial chamber found, in this case, in short, in summary, that the prosecution by and large had proven the case with regard to this crime base, that these crimes had happened. With regard to responsibility, Mladic was charged with all the modes of liability that are provided for in the ICTY statute. So these are committing, more specifically, committing as participant in a joint criminal enterprise with the objective of committing these crimes, planning, instigating, ordering, and aiding and abetting. He was also charged with his function as a commander under the doctrine of command responsibility. Now, the focus during the presentation of evidence, I would say, and in the submissions by the parties, in final briefs and pre-trial briefs, and therefore also in the judgment, was on the alleged joint criminal enterprises and Mladic's role and participation in these. And in this respect, the trial chamber did find that Mladic had participated in all these 4 joint criminal enterprises in various ways, but in particular by acts that we can somehow summarize by under the heading commanding and controlling the Bosnian Serb army. Bosnian Serb soldiers, so the soldiers in this army, were found by the chamber to have been tools, have been used by this joint criminal enterprise to carry out the crimes. So Mladic was convicted on all counts except one that we'll come back to soon. He was sentenced to life imprisonment, and as I mentioned, the case is currently pending appeal. So that's the shortest summary you probably ever will hear about on this case. I was assigned to this case in 2010, so a while ago. It was before Mladic had been arrested. In fact, it was before. It was at the time, I think, when no one thought he would be arrested, at least not in chambers. It was a time when no one thought the case would go anywhere, which is now, when I think about it, it's probably why I was assigned to it. So 7-8 years working on one project is a very long time. Some of you are probably doing PhD, or some of you have been doing PhDs, and I'm not saying PhD takes 8 years, but some are apparently. But it's a very long time, and it's enough time to somehow question what you're doing and question the project. It's very hard work, and it's difficult to kind of keep the let's say the enthusiasm for such a project when going on for such a long time. I think for me there were 2 things. First of all, I was somehow everything came together, and I was happy to work with the best legal team that has ever worked on a case in international criminal tribunal. That makes a big difference. Another thing is that not every day, then every week, there were always some exciting new legal or factual issue, something that we haven't really been confronted with before, and that helped to keep the enthusiasm and keep the spirit and keep it interesting for all those years. I think any of these issues that came up, and there were many of them, could be interesting for a speech like this. The time we have we have available would somehow just allow us to scrape a little bit on the surface. So and it's difficult to choose which one. But what I thought I should do is to pick one that I will talk a little bit about, one specific question, maybe mention a few more, and then I will head into questions and answers to see if there's any you're interested in further. Now the idea, we are in this somehow academic setting, a research setting, so the idea is not to give somehow a complete account of anything, but maybe to give, hopefully give some ideas also for people who are thinking about writing articles or research projects or whatever it might be, longer research, to give some ideas of interesting issues that are still out there even now at the end of ICTY. The specific issue I wanted to say a few more words about is how the trial chamber dealt with the crime of genocide. The prosecution in the case charged the crime of genocide under two counts, count 1 and 2 in the indictment. Count 1 covered what we described earlier as the part 1 of the case, which is the ethnic cleansing in the municipality in 1992. The indictments, I think, mentioned covered 14 municipalities, but the charge of genocide was more limited than that to 6 specific municipalities where the crimes had been particularly serious. Now, count 2 covered what we previously referred to as part 4 of the case, which is Srebrenica part of the case, the killing of 7,000 men and boys over the course of just a few days. As I mentioned, Mladic was not charged with having committed the crime of genocide as a physical perpetrator. He was charged with all modes of liability, but in particular joint criminal enterprise, participation in a joint criminal enterprise. So what the chamber did was to first proceed to look at whether the crimes happened, whether someone had committed these crimes, and then moved on to see whether the accused could be held responsible for them. This is the, as you all recognize, hopefully, definition of genocide as it's set out in the ICTY statute. It's probably by word. I'm quite certain about it. Word by word, it's the same definition we'll find in the 1948 Convention on Genocide and the ICTR statute and ICC statute and so on. It has remained the same. There is something, there's probably something uncomfortable about the definition and some of the understanding of genocide as it comes out of this definition. Because when we comparing with the general perception, when we talk about genocide, we have to often think about something that legally is more close to extermination or mass murder. So generally talking about it, it seems like the seriousness of the crime is in the actus reus, is in what you do, so and a large number of killings. If you read this definition, that's not necessarily what the legal definition is. Here, in the legal definition, the seriousness is in the intent, or what we call the in particular intent. So this is in the first part of the definition that highlighted in this slide. This is the particular intent. With intent to destroy in whole or in part the national, ethnic, racial, or religious group. So this is where the seriousness is there. Just to look at a few of those elements and see how they were dealt with in the Mladic case. First, the word destroy. So potentially this is quite a broad concept, especially when you talk about groups, how to destroy a group. The travaux of the Genocide Convention, however, limited to physical and biological destruction. Still, one could argue that it can be quite broad. physical destruction of a group one could argue at least, it could be something that goes beyond somehow the physical attack on the individual members of the group. For example, you take members of a group and move them in, forcibly displace them in all different kinds of directions. You have no group left. There's a physical destruction of the group. However, it's not generally how it's understood in the case law. How it's understood in the case law is that this limitation to physical biological destruction is what distinguish this crime from crimes against humanity, in particular persecution as crimes against humanity and deportation as crimes against humanity. So for those crimes you would have an intent to deport someone or intent to discriminate against someone, while in genocide you have intent to destroy the group. So it's something separate and something arguably worse, more serious. It's on this issue that you'll find the only dissent in this Mladic judgment, the trial judgment. Not on the legal issue, how to understand the word destroy, but simply how to understand the facts of the case. With regard to count one, so the events in the municipalities in 1992, the presiding judge of the Centre felt that the evidence was not sufficient to show that people who committed these crimes had the intent to destroy. They had the intent to displace them from the municipalities, but it didn't amount to intent to destroy. And here he differed from the other two judges who concluded that that was proven beyond reasonable doubt based on the facts. So there we have a dissent. The next part of this definition, in whole, it's simple enough, but of course it requires that we know what we are talking about. What we're talking about are the protected groups. So the protected groups in the genocide definition is national, ethnical, racial, and religious groups. When you have such an exhaustive list, you can probably imagine the kind of negotiations that have been involved in order to get to that point, and there were indeed, when the definition was first drafted, huge discussions, and among other things, discussions about whether political groups should also be part of this list. They were not included, which part of the reasoning at least was that they were not considered stable or permanent enough as groups, and therefore they could not be part of the list. One could argue, of course, whether religious national groups are more stable than a political group, but nevertheless that's where we are. There were some thought put into why these particular groups should be protected. Now, in the context of the former Yugoslavia, what was charged in the Mladic case and what was considered a protected group here was the Bosnian Muslims. So Bosnians, that's clearly a national group. These are people who are citizens of Bosnia or coming from Bosnia, so that's a national group. Muslims, obviously a religious group. What was charged is something then subgroup, let's say, of that. Something more specific, so a more zoomed in version. How the trial chamber in this case and in all other cases that have dealt with genocide have accepted that this is a protected group in the genocide definition. It hasn't really been much challenged in the case, so it hasn't really been a big litigated issue. So there might be a reason why it hasn't really been, why chambers haven't gone in or somehow developed their thinking more about this. But but it is an interesting or certainly an important issue, because the more you zoom in and the smaller you make the group, the smaller you're allowed to make the group, you could argue the easier it is to prove genocide. What was charged in the Mladic case was not that there was an intent to destroy the whole Bosnian Muslim group. What was charged was that only a part of the Bosnian Muslim group. So for count one, it was the Bosnian Muslims in these municipalities, the 6 municipalities, and for the Srebrenica part of the case, it was Bosnian Muslims in Srebrenica. So that was the part of the group. Now, what does part of mean? A part of a group, at least for lawyers, could of course mean one person. That's another, as far as most extreme. What case law on genocide has shown is that it has to be, well, has clarified that it should be a substantial part. It should not just be a part, but a substantial part, which might exclude 1 and 2 and some other things, but it doesn't perhaps give much more guidance than that. So a substantial part of the group, this clearly seems to have something to do with numbers, absolute numbers. So how many are the, let's say, the Bosnian Muslims in Srebrenica, but also maybe a comparison. How many are then compared to all the Bosnian Muslims, all the Muslims living in Bosnia and Herzegovina? So absolute and relative numbers. Now we're into math, maybe, which always makes lawyers a little bit uncomfortable. And beyond that uncomfortableness, there's also something seems almost inappropriate of kind of starting to count persons in order to see whether it's genocide or not. So in the case law, these indications of numbers, absolute number, relative numbers, as seen as indicators among other indicators, and then other indicators have been introduced. For example, almost at the quality of the group, maybe that's not 100% correct, but who is in the group. So, for example, if you have the leadership, even if it's a small group, but it's the leaders of this group, then destroying them or targeting them would have the potential of destroying the whole group. So that's why a low number could be elevated to substantial. Now, on this particular issue on what is a part of the group, this is where the trial chamber went one way with regard to the genocide in the municipality, another way for the Srebrenica part of the case. So for both of them, it was clear that the absolute number, the number of Bosnian Muslims that we were talking about in the municipalities in Srebrenica, it was high. We're talking about in the thousands, so a high number. Relatively speaking, very low. And the Bosnian Muslims in Srebrenica, depending a little bit how you count, but maybe amounted to 1 or 2% of the total protected groups. And the same thing if you look at any of the municipalities, sometimes less than 1%. So 1, sometimes less, and maybe up to 2%. So very, very low. What the trial chamber did with regard to Srebrenica was to then look at other factors, and we're talking about the symbolic impact it had of the attacking the Srebrenica. Was a UN designated safe area, and the strategic importance of the Bosnian Muslims living there. So that reasoning somehow made the chamber conclude that here, even if the numbers are low, this is sufficient to make them a substantial part of the Bosnian Muslims, or all the Muslims living in Bosnia and Herzegovina. With regard to the municipalities, they didn't find any such factor. Maybe the Bosnian Muslims were in the thousands, but the numbers were low, and no other particular indication that they that somehow would raise them to being a substantial part. So that part, so that's why the count 2 was a positive finding, was a conviction, and not count 1. That's where it fell. So there was a few words on the on one specific issue that came up in the case. So there were quite a few others. I think what I will do is to stop here. I will promise to indicate maybe a few other possible topics of interest. Someone is smiling at the first one. It's a very serious topic. The use of adjudicated fact, which is there's quite something written in the judgment about that. It's a procedural and very technical issue in a way, but something that a lot of time was spent on. So there are these, but there are probably a large number of others that could be of interest to speak about. But I think maybe instead I'll hold there and invite any questions or comments or concerns that you have.
Thanks a lot for this very interesting presentation and also for summarizing those 2,500 pages for us, but also encouraging us to actually read the whole judgment in its entirety, because everyone wants to know where those 4 missing witnesses are, if my math is all right. So there was already one question from the gentleman, but maybe it has already been answered in the meantime. Would you like to repeat?
No, if you haven't have listened carefully, it hasn't been.
Okay. So you would like to elaborate?
I do remember vividly your question.
And maybe another sort of challenging question would be, if what could the UN have done more to protect the people in Srebrenica? And what would you say, third and last, if there would have been a Swedish battalion over there instead of a Dutch battalion?
Yes, then I probably should take something else.
Let's take a couple of questions. Yeah. In the back.
Hi. Sorry, this is not really a question, just a request. Please, if you can put, I missed the slide part 2 with the charges. I think it was Sarajevo. Slide 5 or 6. Yeah, thank you.
That one? Yeah.
Anyone? Yes? Tina?
Thank you. I have a question about genocide, because genocide has been proven to have taken place in the famous CICC trial. So, to what extent was this again examined, the fact of that it has taken place, or is it that in this specific case the perpetrator Mladic has been linked to the? Well, it's actually the question is, has genocide? Did genocide as such had to be proven again in this new trial?
Take those first,
yeah,
and then see if there's a second round.
Yes, maybe I'll start from the back. Then it had to be proven again. Is the short answer. There were certain, again, thinking about the topic that we mentioned before, adjudicated facts, there could be certain factual circumstances that the took judicial notice of that didn't have to be proven again. But by and large, it had to. It was not something that was settled, if I put it like that, when the case started. It's something that had to be proven one way or the other, through adjudicated facts or through evidence. Not that it happened, but that people were committed, people who committed it. So, and in particular, that the accused committed it and is linked to it. But I hope that answers your question. It was the first question was who ordered the killings of in Srebrenica. There is an interesting passages in the judgment about when, more or less. Now I can't remember the dates in my head, but there is during a certain night when men and boys are being captured, detained, and held, and there's discussions between the military leadership and Mladic is around, and there's no meeting, there's no order, written order. There's no meeting where we have minutes where it says where this is set out. But the trial chamber looked at various indications, what was said on a certain day, and what was said in the evening, what was discussed with various people, and then suddenly what was discussed the day after, and what, in particular, what some witnesses, some insiders did testify, what they were indicating. And it was possible to somehow pinpoint, more or less, almost not by the hour, but which night this decision must have been taken, when it was, when the decision was taken that from deporting or capturing or whatever these men, the decision was taken that they should be killed. Now, I don't know exactly who did it, but there is certainly an implication that this is the whole military leadership was, the high military leadership of Bosnian Serb Republic was involved at the time, and Mladic was present around this time as well in Srebrenica. So certainly an implication that he must have been involved with taking the decision. I don't think there is a finding on this particular, and it didn't really have to be a finding on it in the context of the joint criminal enterprise. Had it only been charged with ordering, then it would be perhaps necessary to go that far, and maybe it's not possible to go that far, because again, there's no written order, there's no meeting minutes or anything like that. It's somehow what you can understand from the change of attitude by people, the high military leaders who were involved, and someone who then stepped forward and testified in the case. Whether the UN could have done more is a little bit outside my, much outside my work. Whether, I mean, it's very clear to anyone who reads the story about Srebrenica that they were seriously understaffed and not at all ready for assisting in any situation like this in any meaningful way. Whether they were Dutch or Swedish, I don't think made any difference. Would have made any difference at all, I'm afraid to say. No.
I basically asked the question that way to avoid you criticizing the Dutch.
Yeah.
So you could criticize your own country.
Okay.
So that was the reason.
Yeah. No, in a sense, there's nothing to. I mean, again, it was from a perspective of looking at this case through the eyes of this particular case. It's not a question of criticizing. It's a question of whether they were at all in a situation to assist in this military campaign that was somehow well beyond what they could have prevented and dealt with.
Khalid, yes. And then Manuel. Yeah, Mike is coming.
Thank you. Khalid Ahmed Chaudhry is my name, from International Human Rights Commission. We could see the commander of peacekeeping force, UN peacekeeping force, was enjoying the Serbian wine in his hands, standing with the Serb military, allowing them, to take away 8,000 Muslim men. And my question to you is, were there any arguments about this whole situation, that what happens, the moment these 8,000 Muslims were removed from that camp and till their genocide, killing, some kind of communication between UN, this UN peacekeeping commander, and some other European Union governments. So do we have any picture that within those couple of hours or days, whatever the time was from taking them away and killing them, that these governments of European Union were involved, peacekeeping forces and the UN Security Council or UN Secretary General was involved in anything, to save this happening? Thank you.
Hey, Jonas. Question. The Mladic case and the Karadzic case are quite similar. The same, as I understand. I mean, they're on the same indictment at some point. And I'm wondering, and I assume you've read the Karadzic judgment in more detail than I have, maybe others in the room. And I'm wondering whether the Mladic trial judgment, and the Karadzic trial judgment, whether there's any findings of fact that are sort of incompatible with each other, especially with respect to convictions, i.e. Srebrenica, and not specifically Srebrenica, I'm wondering about, but maybe there are others that I don't know about, and whether you have any comments on any sort of discrepancies that may impact one another.
Hi, I'd like to know what was the defense case? Could you give us like a few ideas on how they managed? Thank you.
And then there was another person, I think, just sitting opposite. No? Yes.
Sorry, I'd like to have a question about your presentation, maybe a small one about the content. I was very much astonished that you used still a picture of this Thermopylae camp, supposed to be a Serbian concentration camp, which has been proven to be a hoax. And you still use it. Why do you do that? Is that now a good idea? My question is, because it's not related to this, we are talking again about 8, or at least you said some thousands of victims of Srebrenica. Is there any evidence I know of Finnish pathological teams having searched there, and they gave some evidence that many of the corpses found might have been corpses fallen in the conflicts around Srebrenica by the UCK and then be replaced in mass graves, so to also there to make a hoax of the mass killings. I'd like to know whether this is taken into account in the proceedings. Thank you.
Thank you. Let's maybe do those 4 questions and then we can start the third round.
So the first, if I understand your question well, whether there was any communication from the Dutch battalion at the ground after, or somehow arguably when they if they did start realizing what was happening. Of course, they were in Podgorica and saw what happened to the women and children. My answer is that I'm not really sure. I don't really know what the communication was.
There was no discussion during the trial.
It was not part of the. It might have been, but it's not really. It was not really crucial for the case, and so to the extent parties presented evidence on it, was not important for the purpose of establishing guilt or innocence of the accused in this case. What exactly the actions of it's important for other reasons, but not for this case. What the international community did, or whether they did it sufficiently at the time. So I'm afraid to say that I simply don't know really the answer to that. Manuel, you had a question about the Karadzic case. It's indeed it's very similar indictment, almost identical. You say whether they are. You used the word compatible. I probably wouldn't use the word compatible. There were 2 different cases and proven and somehow presented on their own. So I don't think there was a particular problem if there were findings made in one case and that were not could not be made in the other case. And there isn't, of course, a specific example of this. I think you were kind enough to say that I probably had read the Karadzic judgment better than you, but I have not, and there was also somehow a conscious decision of not reading it while working on the Mladic case. But what I do understand is that on this particular issue we discussed on genocide in Srebrenica, I think that in that case they found, just like the dissent in the Mladic case, that it was not proven that people had the intent for the municipalities, sorry, not for Srebrenica, for the municipalities that didn't have the intent to destroy the group. Majority in the Mladic case found that no, there is intent. Problem is that the group is not a substantial part of the Bosnian group. So they fell on another point. So there is that difference, and there might be many differences also looking at specific counts. But it of course has to do with whether they presented the exact same evidence in both cases, and of course also how the judges assessed the evidence. So it could very well be, it could be unsatisfactory somehow from a historical point of view, but it can of course obviously happen that they decided things differently. I hope that somehow responds to your question. Thanks. A question about the defense case. If I can say something about that, I gave a little bit of an indication, perhaps the number of witnesses. There was a substantial defense case put on. I would like to say that it somehow explain what it was focused on. But I think they challenged many different things. Certainly the responsibility of the accused, that was one part, but in fact many of the crime-based parts of the crime base as well. It was a very, if I say general, maybe it doesn't sound very good, but it covered many aspects of the case. It was not a defense case that was somehow, we accept that all of this happened, but our client is not responsible for it. It was challenging many more things also throughout the crime base. So, which of course, that requires a lot of evidence and a lot of witnesses. So, all in all, in total, I think the prosecution called more witnesses, but as you saw, the numbers were.
But what was the main challenge?
It's difficult to say. I think the main challenge probably would have to be the accused, whether he had anything to do with it. Argument about, for example, during the Srebrenica killings, that he was not for a certain period in Srebrenica. He was in Belgrade, and so of course it was very focused on him. Certainly during for the 1992 part of the case, that he was never present at any of the crime incidents and so on. He took steps to deal with the crimes afterwards as soon as he knew about them. These kind of things. So that I would say is the focus, as I can imagine. But I think the significant thing is that it went much broader than that, and it even went into specific crime incidents. And then I think we had a comment on the Trnopolje camp picture. It's probably absolutely right that that's one of the pictures there is from the Trnopolje camp. There is a section in the judgment about about that camp, and it's quite set out in quite some detail about what it is. It was, I think it's safe to say, it was a little bit different than many of the other camps, but not that much different. And certainly it existed, and people were detained there. And that's certainly what the chamber found, and not only this chamber. Of course, this has been found by numerous chambers of the ICTY. So I probably wouldn't agree that it's a hoax, particularly.
The picture.
Sorry?
The picture is the hoax.
The picture is the.
Mise en scène.
Yeah. No. Yeah. That I think the man of the picture was also a witness. So that's perhaps I'm not sure what exactly is a hoax about it, so to speak, if the camp existed and people were detained there. But
it has to be recognized all over the world as a hoax.
Yes.
So the fact of the
Let's maybe
accusation is
raise hands if you want to ask a question.
It's just a picture. That's all.
Okay.
The other issue you raised also was Srebrenica and the existence of forensic documentation and so on. And I think there's also set out quite some detail in the judgment. A big part of the Srebrenica case is forensic evidence. It's evidence not only exhumation reports finding these people, autopsy reports looking at how, to the extent possible, seeing how they were killed, who they were killed together with, how they were buried in mass graves and so on, and also identification, who these people are, where they come from, specifically. So that's, I would say, an area that is very well explored, very well investigated, I mean, there's quite a lot of to put it very mildly, material, forensic material, documentary evidence on this. There are very few. There are few survivors. Many of the people who were victims of the Srebrenica massacre were, of course, killed. There are a few survivors who tells the story about exactly what happened, but to a very large extent, for many of these incidents, somehow the answers has to come by concluding from this forensic documentation. People found in the same grave, having been last seen by their relatives in a certain place, but both the exhumation and the autopsies and the DNA identification of who they are, it's quite advanced and were presented to the chamber, because this is something that has been developed throughout the years of the ICTY, and more. But at the stage of the Mladic trial, it was really a lot of material on that. There's still probably mass graves out there still to be found, certainly. There was one mass grave found during the course of the trial, not with regard to Srebrenica, but with regard to another part of the municipality part of the case. That was found as late as during the trial, and I'm sure we'll find additional mass grave also in the future.
First that lady. Yeah. Very politely, please. No, sorry. You, behind? Yes, and then you.
I would like to ask a question about this insider view. You promised us in the title of this lecture that there will be some secrets you will be telling us, and so far I must say I haven't heard much of these secrets because all you have been talking about are things that can be found in the judgment or in other open sources.
I couldn't tell you anything.
But
that
I
you don't know
can
better than
help
me.
you with that. Looking at the judgments, the size is enormous. So it seems to me, compared, for instance, with Krajnik's judgment, 500 pages, less than that. So the amount of analytical work done to write this judgment was certainly incredible. I have glanced through the judgment, and I must say it's impressive the work you have done as a team on cross-referencing related pieces of evidence. I think it is a huge effort, knowing that there were 10,000 exhibits in the case, to find the pieces that match each other or not, and make a comment on this. Perhaps you can tell something about how you worked on these kind of issues as a team. How large was your team? Who were the members of the team? Was this only highly qualified staff of experienced lawyers, but perhaps you also used some help of interns, legal interns. There were plenty of them in the ICTY. And a follow-up question about numbers. I actually feel strongly attached to numbers. You said that in the context of your comments on the genocide, that relative numbers were quite low. In this context, I would like to ask a question about how did you, if you at all, look at migration during the conflict period, especially in the first year of the conflict. Forced migration, conflict-related migration was massive in Bosnia and Herzegovina, so it reached about 50% of the pre-war population size. Most of this migration took place in the first months of the conflict. So if you take as a basis for the comparison not the pre-war population but the new population, much smaller population which resulted from this massive migration, that this might have impact on the relative numbers, of course, of the affected persons killed, but also, well, migrants, forced migrants who were also victims of the conflict.
Thank you. Leslie.
Yes, thank you. I have two questions, actually. The first one is in relation to a question that was asked before in the back about the definition of genocide and whether or not you had to address it again when you looked at the Srebrenica case. I think you said we didn't have to examine the facts again only in relation to the role that Mladic himself played, but the actual facts itself we didn't have to readdress. Did I understand it correctly, or did you actually have to reassess the situation itself and ask yourself the question, was there actually genocide in Srebrenica? Because you did mention in your presentation a lot of criteria and how Srebrenica was special and how that was actually found in this case. So I was wondering, did you actually reassess the situation in Srebrenica and test it to the definition of genocide, or was it only the role of Mladic that you had to examine in this case? And if it is the first case, and if you actually do have to reassess the situation, was there a real chance of finding something different than was found before in the earlier cases? And if so, how would that stand if you actually assess the same situation, different trial chambers, coming to a different conclusion? I was wondering how you see that situation. And the second question is something that was also mentioned before, the relationship with the Grotius case and how the indictment was very much the same. The sentence was not the same, and of course it was a totally different case, and you said you haven't really read it in detail, but you've obviously heard the sentence, and it was not a life sentence but 40 years. Could you maybe give some secret insight as to what brought you to this sentence rather than, well, a similar sentence as Grotius?
Thank you. Yes, please.
I was wondering if, in light of some of the questions that were just asked, maybe you could say something about, maybe not for my benefit, but for the benefit of others, about how the chamber used adjudicated facts, given the fact that Mladic was the last trial and many things had already been adjudicated upon, and, well, yeah.
Okay, final one.
Sir, I'm still stuck with my previous question, but I'll phrase it a different way. You want to believe us that there were no questions raised by the judges to the Mladic, that how could he manage to convince the UN commander to hand over the men, and what kind of discussion they had. So, and if he was told by Mladic and others the purpose of taking these people away. Thank you.
Okay. Yeah, we'll try, and then we'll see. You have to remind me maybe if I lose some. Maybe I don't know if I can start with yours. So the answer that I gave before about whether genocide had to be proven again. Yeah? What I meant to say, it had to be reassessed all over again. There was not a starting point where genocide happened, and now we'll see whether he is responsible or not. What had to be looked at was, did someone commit genocide on the ground, and then were the accused responsible for this? So this thing had to be reassessed again. Your follow-up question to that was, would it even be conceivable that you would have come to a different conclusion than another trial chamber who were looking at the same facts? It was not only conceivable, it did in fact happen. It was the example we mentioned here before, where I think in the Karadzic case they found that for the municipalities there was no intent among people who committed the crimes, no intent to destroy the group. So that's why there was a negative finding in that the Karadzic case. But in Mladic case, they said no, there was intent. There was exactly. Evidence could be presented, different evidence in different cases. It's actually the same crime base, and different judges make this different conclusions. Again, it's difficult to say whether it's the judges are assessing the evidence in a different way, or there were really different pieces of evidence that they had access to. But it's possible, and it's not particularly problematic that you would have two different findings in the case. Ideally, what would happen, of course, is that you try them together. These are the same indictment, and that, of course, they were indicted together originally, these two. That would have avoided these kind of discussion of problems, if I think there's a problem. But now there were separate cases, so that's what happened, and it could happen. Not necessarily a problem on that. So what do we jump to next? Yes. What is the difference? So what differed the sentence? I know the sentence in the other case, and of course it's different. The factors that you take into account in sentencing, it's always very difficult to compare two different cases. If you look at all the cases ICY has had and all the judgments, this is probably one of the big issues of trying to make sense of why a certain person gets a sentence and another. But because it has to do with the crime, obviously, and that's somehow where we get stuck a little bit. We're thinking that that this is the same crime base. So it's Srebrenica. We think that looks in a certain way, and therefore the same sentence should be for everyone who's been involved. But the type of involvement can differ very much. The participation in a joint criminal enterprise can look in many different ways. It has to be a significant contribution to the joint criminal enterprise, but it can factually look in many different ways. There can be people who are much more active and doing many more things than others. Then of course you have the individual circumstances of age and so on as well. So I couldn't pinpoint exactly why. What is the difference in these two cases? Even if the indictment, or to a large extent the outcome is very similar in terms of counts that they are convicted on. But the factors of sentencing are simply too many to be able to see exactly where they differ. Not a very satisfactory answer, but that is unfortunately what we have. We'll jump to the question of numbers, maybe. You asked whether the migration had been taken into account, and of course you're really right that would have changed certainly the relevant number if the number of Muslim in a municipality would be much higher than it was in 1991 or whenever the census taken. Then, of course, the percentage would differ. If we're talking about 1-2%, it's not that it would change particularly much in terms of our discussion. But nevertheless, it is possible. I think the simple answer is that it's also a question of what evidence was available. What is it? And often, as you know better than me, comes to these early stages, what you have to often cling to was the census and what the documentary evidence said, and then could somehow take into account that there must be many people who left, many people who are right, but it becomes difficult to really use it. So it's a little bit of an evidentiary question, I think. There is something with regard to the Srebrenica part, where this is in 1995, so there's a little bit more elaborate on who was there, and that a lot of people had in fact come to Srebrenica and were there when it started. So that is also taken that is taken into account in that part. That the number is not who were registered in Srebrenica in 1991. No, there is a higher number. So to some extent it was taken into account, but it's a question of when you have solid enough evidence to be able to do it. Jumping to your question here again about the. I'm not sure I have much any particular different answer. Again, you have phrased it as somehow the Dutch commander handing these people over to the Bosnian Serb army. I implied a little bit in the answers to other, more than implied perhaps, that I don't really see it as any kind of handing over. I don't think the Dutch battalion were in any position to hand anyone. I think they were there and in a situation where they were completely unable to manage. Whether the international community, somehow in a broader sense, at that point should have reacted and intervened. We can probably agree on that. But again, it didn't play a big part in this case for a very obvious reason. They weren't targeted. They weren't accused in this case.
So no question between judges and Mladic about what happened at the camp.
No, well, no questions. Mladic himself wasn't, we didn't testify himself, but with other witnesses, either no. I mean, there were questions, and of course, with regard to these meetings, most of them, or perhaps all of them, are filmed, and that was in evidence. So they exist proper records of them. The people, many of the Dutch battalion were witnesses, members of the Dutch battalion were witnesses who testified. Others who were at these meetings also testified. So there's proper, let's say, record of it. But I think your question is more, shouldn't they have done more, or that's what you would like to get at. But it's easy to agree with. But again, I didn't.
If I may ask you all briefly, did they said that okay, we are going to take these people into custody, we are arresting them, or we are going to take them somewhere? I mean, some kind of discussion, some kind of question answers during the trial. When they are
final question.
8,000 people, they are separating them from women and children.
The separation, of course, was different in the sense that the 8,000 men were already on their own and going. But the discussion between the Dutch battalion and the Dutch leader of the Dutch battalion and Mladic was about the women, children, and elderly, and whether they could go or not, and the question of whether they should be screened so that make sure that there were no war criminals among them, and so on. So that was about that discussion. About 8,000 men was not. That was not part of a discussion, as far as I can remember, at least in any these meetings, and that doesn't mean that the international community and Dutch battalions and whoever knew about or has a sense of what was going on and acted or didn't act. But at that point, it somehow didn't play a part in the case.
Thank you. Still a question about adjudicated facts and also still the secrets of the team working on the case.
That to the end, trying to think of something. No, adjudicated facts. Just to tag on maybe to this discussion we had then on genocide, whether it was proven or not. There was in the beginning of the case a large number, on prosecution submitted a large number of adjudicated facts. Adjudicated facts are simply put facts that have been adjudicated in other trials. Not legal qualification, was this a genocide or not, but facts. This on this day, this and this happened. And there were a large number of those submitted and accepted by the chamber. Certain conditions under which you can accept such adjudicated facts. They cannot be about the acts and conduct of the accused. It cannot contain legal qualifications, or again saying that it was a genocide, but to describe factually what happened. And there were many of them submitted and accepted by the chamber in the end, and that's how, with those, the trial did start. And there were some of what effects exactly that had on the idea, or one very important idea, of course, is that should shorten the proceedings. It should allow you, the calling party, not calling evidence on those facts. You have to be proven again. You have the facts already. So that might have a certain effect. It's a much bigger discussion whether that actually had that effect in this case. This was, together with the Karadzic case, probably the case where most of such facts have been submitted, and because it happened towards the end of the ICTY, and many cases had been adjudicated on Srebrenica, on the municipalities in Sarajevo, and so on. So a lot had been said that these facts have to go through trial and appeal, and that had happened in many of these cases. So there was a lot of that, of those facts that the case started with. Whether it actually had an effect on shortening and that they called fewer witnesses, I have perhaps my doubts about. So in that sense, but that, again, just to come back to that question, that doesn't mean that case somehow started with something proven already. These are part of the proceedings. These are facts that are introduced, not as evidence, but somehow in a different form. So that's about adjudicated facts. So a little bit, I don't know, insider view, but a little bit about how we worked. Typical team in chambers, at least traditionally, would consist of maybe 5, 6, 7, 8, 10 people. In this case, we was doing another case in parallel in the beginning, but also for other reasons, we had much bigger teams. We had about 15 staff members approximately, and probably as many as the interns, if not more, 20 interns. So more than 30 people at some point. I think it's probably as big as a team ever has been in chambers. It was a big group to work with the judges on this particular case. How you write a judgment? I mean, there are thousands of different things to say. I mean, one very important thing is that you start in time. When do you start writing a judgment in a case of this kind? I mean, you have a situation where the judges are in court, sometimes 5 days a week, or certain, from not part of the case, they were in court 5 days a week, hearing evidence, and then with certain breaks. So what you have to start doing is to start processing this evidence from the beginning. Not necessarily start making findings. I mean, it's impossible to make proper findings because you haven't heard all the evidence. But there are many things you can do in terms of processing, in terms of shaping this evidence that comes in through witness statements, transcripts, what been heard in court, expert reports, or whatever it might be, and shape this into something that can look like a judgment. And then at a certain point, the judges will have to start making findings, and they have to be drafted as well. In short, the judgment drafting in these kind of cases, and it's absolutely certain the same thing in ICC, ICTR, whatever are these international tribunals where the cases are of this kind. You start from the first day of hearing evidence, if not before that, to work on it. Otherwise, it's impossible. It's not the case. I mean, it has nothing to do with a case in a national system where you hear the evidence and then, okay, now we go back and start thinking about this. If you go back and start, after having heard the evidence, and start reading 10,000 exhibits, try to understand them, and 600 witnesses, it will never be done. It's a process that is constantly ongoing every day for the day of the trial. It's not very much insider either. I want something.
Secrets probably must remain secrets.
There are some secrets that has to be secret. Exactly.
Yes, I see. One question there.
Thank you. I was intending on reading the 2,500 magnum opus that you participated in, but I decided not to, and I changed my mind after I understood that some parts of it were not published, if I understood correctly. Could you explain why that is the case? No pun intended.
You want to read
Thank
even
you.
more? Yeah.
Hello. I'm a historian, and I'm wondering if you were ever and your team aware that this is going to be an enormous historical source, and that, for all we know, this is the biggest collection of sort of historical evidence that relates to the war in the former Yugoslavia in the 1990s. I'm just curious if lawyers think about that. And as a former Yugoslav, I want to thank you and your team for your work. Thank you.
Should we go with these two questions
Yes.
immediately? Yeah?
Yes.
So the yes, there is a confidential annex which is 15 pages. Is that right? Can we reveal that much? We reveal. That's a secret that no one knows. 15 pages is the confidential annex. About 15 pages. So that's the inside information you get. The reason it's there are certain confidential parts is that there are witnesses who are protected. Many of them are referred to in the judgment, but only not hopefully in a way that can reveal their identity. But then there are certain witnesses who, by just having their story and summarize their story, you would understand who these people are and would reveal their identity, and then they have to be confidential. So that's the essentially the reason why you have to have that. You try to avoid it so that as much as possible is in public, and I think it succeeded also in this case. Sometimes you will have to have a little bit longer confidential analysis, but it depends on witnesses testify how many have protective measures. But it has to do with that. Witnesses whose identity should not be known. They were protected during the trial and should remain so, of course, after the judgment. Next question. Yes, about writing history. This is a big topic as well about the responsibility we should have or not have as lawyers in writing these judgments. This has to do with also this question about there is the Karadzic judgment makes certain findings, and the Mladic judgment makes certain other findings. That doesn't make very good for history, or that might be good. It becomes a bit of a mess. But it's not a problem for lawyers, as I mentioned. It has to do with what evidence you have. I think you are aware of it, but not so much. I think not so much to some extent the judgment, yes, because it's a wonderful piece of writing. But I think in particular what you're referring to is the 10,000 exhibits, the 600 witnesses. That's the great value, and that's somehow, to extent it's public, and much of it will be public, of course. That's of course the great source where historians and others who will look at it have it free and available to analyze, and they come to completely other conclusions for sure than a chamber would do, who are looking at one accused and who are looking to prove beyond reasonable doubt. But when you write it in a historical context, other considerations. So aware of it, but never be a consideration when you write the part of drafting a judgment. That's a completely different focus than somehow imagining that you are creating a complete truth. It's the beyond reasonable doubt standard, and it's about one particular accused. That's in the end what it's about.
In view of the time, let's conclude here, but not before I've abused my position as chair or moderator. I had one question, because we had many factual questions have been asked, and I was wondering, to what extent, what do you think is the most important value of this case from a jurisprudential point of view? So from a legal point of view, what is the legacy of the Mladic trial? Looking at lessons learned for other tribunals, what would be the main lesson learned from this trial?
Yes, I mean it's easy to answer what we discussed today. There is some interesting discussion on genocide, and the ICTY didn't have that many genocide cases. So there is some interesting point of in that respect that I think somehow will remain. Otherwise, the whole, of course, JC discussion, the Joint Criminal Enterprise discussion, this is towards the end of the ICTY's life now, a Joint Criminal Enterprise concept, where the first discussed in Tadic a long time ago, a very small case, but with an idea that this should be applied to big military and political cases, that it should be possible to apply, and it was applied in this case. And whether that's successful or not, I mean, in this case, in the Karadzic case, you would have never have as much distance between the crimes happening on the ground, distance in time, geography, somehow distance between perpetrators on the ground and the ones who are in the JC. So it's that's an interesting thing to study, whether you have stretched this concept of joint criminal enterprise too much, or the somehow extent to which you can stretch it. I think there will be no cases where will go further than this, because of the facts of cases. It's very rare to have military political leaders so far away from the crimes. You have them in ICC, but when they have acted in different capacities, closer to the ground. So that discussion, I think, as well, is interesting to study. The big, I think, the big legacy for me, I mean, ICTY wise, and this case in particular, Karadzic case as well, it's the fact that it can be done. That the fact that you can have these trials, it's possible to everything from possible to arrest these people, it's possible to bring them to justice, but it's possible to have a trial. It lasts many years, but it's still possible to have it and to conclude. I think that's the big, certainly that's the big legacy of the ICTY in general. I studied law a long time ago in the 90s. My first international criminal law course was I studied in 1997 in Antwerp. We started in January, and we were discussing international criminal law as it looked at that time. This was extradition, mutual assistance on criminal matters, and a Surin case, and I don't know what. In May that spring, the Tadic judgment came out, and that somehow changed the focus on these kind of cases. And since then, of course, this has been a field in itself, and no longer is questioning the legitimacy of the field itself. We can discuss a little bit how it should be done, the details of a trial, details of definitions and so on, but that it should be done, it's not really questioned, and also that leaders are supposed to and will be held responsible for it. This is somehow the big legacy for me, the ICTY.
Thanks so much.